Hi, this is Professor McLaughlin with your Chapter 2 video lecture. Chapter 2 really gets us to the heart of where the fundamentals of criminal law reside. It is all about constitutional protections, and you have one homework that's through Canvas and not Connect, that is really all about looking at the criminal defendant and understand the potential alleged criminal defendant as a police officer, and understanding the defendant's rights and the limitations on law enforcement. And I want you to think about balancing when you think about the Constitution, regardless of whether it's about criminal law or civil rights or civil law. A lot of business law goes to the U.S. Supreme Court. A lot of business law cases go to the U.S. Supreme Court, and a lot of them have nothing to do with the Constitution. They really have to do with government regulation of copyright and intellectual property, or the Securities and Exchange Commission's enforcement action against publicly traded companies. And for any of those, including, we're going to go through one of your cases from this chapter today in this lecture. You're constantly looking at balancing. So you're the court. I say you because in some of our homework, you'll be the Supreme Court justice, and you'll be the police officer, or you'll be the lawyer advocate. We're balancing the right of the government to do something and the power of the government to do something against the protectionist rights or the protections of the Constitution for individuals and entities. And you could even flip that. You could say the rights of individual and powers of individuals and entities, and sometimes balanced against the power and rights of the government to do what they need to do, because the government does lots of things. It keeps society safe. It paves our road. It responds to natural disasters. It takes care of national forests. And I just want to instill in you this ability, this skill, to just sit and balance and understand that constitutional decisions are balancing activities. All right, let's get going. And I guess I will say this is the book that the college uses. And so if anything upsetting or don't read anything in the book. We're dealing with criminal law, and sometimes there's upsetting cases. I'm never going to assign them to you for homework. I mean, they are assigned, I guess, as reading, but go skim through it if possible, and please let me know if you really object to the content in the book. As I said in my first video, it's my first time teaching this course with this book. And so let's have an open dialogue about what's working or not working in terms of subjects that you may not really need to be facing at this stage in your life, if you know what I mean. So let's have that dialogue. So the criminal law, let me adjust this real quick. I want to make sure you're remembering from where, I don't want to say the wrong name of the class, but if you're taking a social studies class or a civics class or a American government class, just remember that we have a federal constitution and a state constitution. And the government is, for sure, like the legislature in California is drafting the California Penal Code, and the Founding Fathers drafted the Constitution, and then Congress can amend it and update it, and that is very much a social and voter participatory process. And no state can draft in their constitution something that is at odds with the federal constitution. They all must be consistent, and laws that are written must be constitutional. And frequently, the cases that go before the Supreme Court are questioning some are questioning the constitutionality of substantive criminal law, which is, arson is the burning or of a structure. That's substantive. Murder is the killing of a human by another human with malice aforethought. And also sometimes it's just about procedural things. So the constitutionality of the actions of law enforcement or corrections officials. So laws can be declared unconstitutional if they violate the federal constitution at all, the amendments, or the state constitution. And we declare criminal statutes, like the California Penal Code provisions in the criminal statutes, unconstitutional if, and these are terms of legal art, if it violates the U.S. Constitution on its face, which just means the way it's written. Or did it violate the California or the federal Constitution as it was applied or by application? And I would love to hear from you if that's a confusing concept. The way I'm trying to think of a recent example. Back in the day, I guess about 8 years ago, hate speech statutes were not frequently applied. They were written, but not a lot of states, it's a state law, and not a lot of states had applied it to a factual situation. And the growth of Facebook and at the time Facebook and maybe even Twitter at the time. That might be early for Twitter. But people saying hateful things on some social media could be hate speech, and how states enforce their hate speech statutes was inconsistent and really unknown, because there hadn't been many cases brought under the hate speech statutes. And so violation by application, or as applied, in terms of unconstitutionality, really sometimes takes time after a piece of legislation is on the books and then used. Then you might really discover its unconstitutionality or its constitutionality through court cases. So we have the U.S. Constitution. It forms our government. It creates, through its articles, our form of government, our executive branch, legislative branch, and judicial branch. And then we have the Bill of Rights. So shortly after the ratification of the Constitution, the Bill of Rights were drafted and passed. And these are the first 10 amendments to the Constitution. And they were seen as securing individual rights. And there was a lot of debate over it. And as the U.S. Supreme Court interpreted those amendments, a foundation for procedural criminal law grew from there, a understanding of what procedural criminal law was, an understanding of probable cause, what is a stop and frisk. For years, police were able to confiscate your phone, open it up because it wasn't password protected, and let's just go back as far as flip phones, and look at it. It was not password protected. You could see text messages. But once the phone became a mini computer, it was not immediately agreed upon that police could not force you to give over your password. That took time and constitutional cases going to the U.S. Supreme Court for the court to decide that under the Fourth Amendment, which protects you from unreasonable search and seizure by the government, which includes law enforcement, but it also includes lots of other entities, you are not required to give your passcode. This is not legal advice. You're not required to give your password to police. They can detain you if you don't. And then this is also not legal advice. And that's the choice of the individual. That non-compliance is a choice of the individual to enforce their rights. Let's go through some of these amendments to understand how they provide protections. Provide protections to individuals and to businesses, and limit the government's encroachment on our personal rights. So two other large concepts that sit in this area. One is due process. So maybe you remember your American or U.S. history where England did not want to give up the 13 colonies and would charge people with crimes, things that were not crimes when they did them, and then rule against them in absentia. So without the person even coming before a judge or jury, the person would be guilty and the person would be punished. Due process, this idea that the government cannot take away your rights and the government cannot fine you without some kind of process. And that is usually, and this is procedural due process, and that is usually a notification, an opportunity to be heard, an opportunity to defend yourself. So due process is very much why we want to talk to the manager. We want to appeal a decision of an administrative agency like the IRS, and we are entitled to that. It's embedded, very much embedded in our overall system, but definitely our criminal justice system. So that's that one big concept. Then equal protection, this 14th Amendment idea that it really forms the basis for our concepts of civil rights, treating people equally, ensuring that the government is treating everybody the same. Equal protection and due process are some of the pillars that grew over time as the U.S. Supreme Court interpreted the Constitution. And here are some of the cases that are in your book, and really it boils down to, making sure we're treating people with diverse racial, ethnic backgrounds the same. Gender, religion, sexual orientation are also very important, and equal protection and due process are the foundations of those concepts. But I want you to understand also that developed over time, over many, many decades. So a big, important tool of law enforcement and the criminal justice system is to gather evidence from the criminal defendant. And the protection that the Constitution provides through the Fourth Amendment is the ability to be free from unreasonable searches and seizures. And then it lists, my person, my house, my car, my office. Do the police need a warrant? When don't they need a warrant? Did they need to give me some kind of notice? Did they need to ask? Were they legitimately looking for something illegal, or did they just happen to find it? So a lot of the most interesting cases are there. And then we come back to this idea of let's not retroactively make things illegal, and then let's also not punish more than the crime allows, and that's our concept of ex post facto laws. So let's take a look at the amendments and go through them. I put a small activity video watching for you in your module in Canvas, asking you to look at all the Bill of Rights. It's a YouTube video going through the Bill of Rights, but I'll do it quickly here. Speech is not free. There's a lot you cannot say. And the main thing I need you to understand for the Bill of Rights is that it doesn't apply to us as individuals. Really, the constitutional protections are when you have a government entity or an individual or entity somehow loosely connected to the government at any level, and an individual. You could have two, or an entity, a business or an individual. So you and I do not have free speech rights against one another. I cannot sue you as an individual. But if you were affiliated with a larger organization, or you were a government official at the state or federal level, then my rights become engaged at that point. So First Amendment, you have free speech, free exercise of religion, freedom of assembly, and we have a case that I'm going to talk about in a minute about the right to assemble. You have I'm going to talk about it in 30 seconds. You have the right to assemble. Also, under the First Amendment, you have the right to petition the government and ask for things. But let's sit here for a moment on our right to assemble. And assembly is to not necessarily protest, but it's to get together and speak. And this first case and you've looked at other cases, and you will look at other cases, and there are other cases, but the one I want to highlight out of Chapter 2 is City of Chicago v. Morales. And the City of Chicago is trying to find a way to really reduce drug-related street gang violence. And because the behavior of this kind of activity was people standing around, waiting, and talking to each other and meeting up, Chicago, the state of Illinois, the city, I think it was a state regulation, or it might have been a city regulation. I'll have to take a look. But a regulation was passed called anti-loitering. Anti-loitering would mean that police, so you're not allowed to linger or stand around or loiter, and the police now have a right to disperse individuals as they're loitering, and the purpose is to reduce drug-related drug selling in street gangs. So this is a picture of Mr. Gutierrez, who was arrested by Chicago police and charged under this anti-loitering law. A judge dismisses the case, saying that the law was unconstitutional. It goes up to the U.S. Supreme Court. The Supreme Court declares the law as unconstitutional because it's very vague about what the illegal conduct is with anti-loitering, the way the anti-loitering law was written. And ultimately what I want you to know is that they were concerned, and this is in your book, you'll read it in chapter 2. Well, what if an innocent person, what if their cousin was there? And they weren't really there because they were part of a drug-selling street gang, but they were passing by and they stopped to talk to their cousin, and they get arrested with everybody else, unrelated to the gang that was there, or maybe there was no gang there. Maybe people were just loitering. Unbeknownst to them, one member of the group of people standing there had some prior conviction for drug charges. So that provided too much discretion, according to the U.S. Supreme Court, for the police officer. I don't want my video to be too long, so let's kind of get through these final slides. So the Second Amendment is the right to bear arms. A little controversial about what that is and how that's been interpreted. You have the Third, we talked about the Fourth, the Fifth Amendment. There's a lot of due process and the right against self-incrimination. That's why people take the Fifth. Sixth Amendment is the right to counsel. You don't have to memorize these, but I don't have slides for all of them, but you'll go through them in your book and the video. The Eighth Amendment is the right against, or the protection against cruel and unusual punishment. And here we want to introduce some other concepts that are very criminal justice related and constitutional, and that's of proportionality. And you'll see this a lot in criminal law. We need a crime that is proportional to the punishment. So we heard the Hammurabi Code. We no longer cut people's hands off when they steal something that's not proportional. And the punishment, yes, I'm going to say it, does the punishment fit the crime, and is it proportional? And you'll also see this in defense of property cases, where I believe this is still the law in the state of California. You may not defend your property with lethal force unless lethal force is being used against you. We may get into that in later chapters. And then ultimately the U.S. Supreme Court, over its jurisprudence, and that word means over the course of interpreting the U.S. Constitution over time, because some of the rights that the U.S. Supreme Court have distilled from the Constitution are not actually written into the Constitution. So the right of privacy is gleaned or taken from multiple amendments, and the U.S. Supreme Court interpreted the Constitution as affording individuals the right of privacy against government. So this is just a nice little cheat sheet of the rights guaranteed to you under the important amendments. And you might want that cheat sheet when you do the homework called Analyze This Situation, or The Situation. I can't remember what I named it. Thank you for sticking with me to the end of the video, and I'll see you next time.